All right, we're going to begin the webinar. Thank you for joining us for our Cal OSHA COVID-19 Emergency Temporary Standard webinar. We'll be covering that standard as well as related legislation. This is going to be a very packed webinar with lots of content. We have quite a large audience here today, and we will do our best to answer all of your questions either during the webinar or in follow-up by email. It's obviously a really important subject to businesses right now. This is a standard that was recently enacted that's having a pervasive effect in the workplace. My name is Andrew Sommer. I'm the managing partner of Conmasil Carey's California office, and I have been practicing for over 20 years, and I practice in both Cal OSHA enforcement as well as employment litigation. And I'm going to just give a brief intro for the three of us. You have our slides here with more detail and our contact information if you'd like to reach out. I'm also pleased to be joined by my colleague, Fred Walter, who is our counsel. He's been practicing Cal OSHA defense for over 35 years. He knows the ins and outs of Cal OSHA, and he's quite seasoned and has excellent perspective on Cal OSHA issues. I'm also joined by our associate, Megan Shaked, who has been practicing 10 years and is both an employment litigator as well as a Cal OSHA attorney. So let's just dive in here. We want to leave as much time for the content, but briefly, the agenda for today is the real focus on the emergency temporary standard that was issued by Cal OSHA and took effect on November 30th. We're going to discuss with you briefly the rulemaking process and how we got to this emergency temporary standard, as well as the status of the advisory committee, which will be meeting to consider changes to the ETS. We will cover the written COVID-19 prevention program requirements under the ETS, considerations for how to respond to positive cases in the workplace, and related considerations about outbreaks and testing. Outbreaks occur when there are a certain number of COVID-19 cases in the workplace that trigger a certain number of very onerous compliance obligations that we will discuss with you in some detail. We'll also cover the agency guidance issued by DOSH, the Division of Occupational Safety and Health, in the form of frequently asked questions and answers. There are currently 69 questions with answers, and we'll review some of those with you and explain some of the limitations that those answers have. And then proceeding in the topics for the agenda, we also have a hodgepodge of COVID-19 notification requirements. And this is an area that has caused employers, particularly our clients, great consternation because we have notifications in 3 separate laws, and the terminology in the 3 laws do not exactly align. So we have, first off, the Cal OSHA Emergency Temporary Standard, or ETS, has certain notice requirements for close contact exposures, meaning individuals within a certain distance for a certain period of time in the workplace, as well as notice requirements under Assembly Bill 685 that relates to notification where there are positive cases in the workplace to individuals that are in the work site as defined. And that notice goes to employees and their unions, as well as subcontracted employees. And when there's an outbreak, notice is required to the California Department of Public Health. And last but not least, there are requirements under Senate Bill, actually it's 1159, that requires notice to the Workers' Compensation Claims Administrator where there are COVID-19 positive cases in the workplace, and there's certain information that the claims administrator will do with that information. So moving on, let's proceed right to the Cal OSHA Emergency Temporary Standard. And as background, Our firm did form an employer coalition, and we were involved in the rulemaking process, conducting advocacy on behalf of businesses, and really pointing out concerns that we had with the proposed rule. And what happened here, and this explains some of the issues we're having, is that there was a workers or a number of workers groups that had proposed a COVID-19 emergency temporary rule, and that they did that in the form of a petition. That petition was granted by the Standards Board, and the Standards Board gave a directive to DOSH, the Division of kind of Labor Standards Enforcement of, the Division of Occupational Safety and Health, excuse me, and that was the request was that they come up with a proposed emergency rule. And DOSH came up with that rule, and unfortunately it was a rush process, and there was hardly any impact and input from the business community. And so there were a number of issues with with inconsistencies and ambiguities in the proposed rule that were just not considered and not modified when the rule was ultimately adopted. And so the rule was adopted. It is in effect for 180 days with 2 opportunities to readopt the ETS for a longer period of time, and then this ETS can become a permanent rule at some point. Now, there's one consideration. There is issued by DOSH, Division of Occupational Safety and Health, a number of frequently asked questions with answers. And it's important to note that those FAQs are not the law. They do not have the force and effect of law if you are in a appeal of citations that are issued by the agency. But they do provide some helpful guidance and an idea of how DOSH may come down in enforcement proceedings on this issue. Ultimately, we believe it's important that the rule be corrected and changed to address concerns that have been raised by the business community, among others. And there will be an advisory committee to consider these changes that should be held in mid-February. Our firm has been invited to serve on that advisory committee. There will be about 30 individuals on that committee, and it will include individuals in business, from the agency, as well as from unions and other worker organizations. Now let's dive in to this rule. Let's start off with the definitions. Well, actually, that will be the next slide, but let's just first talk about the scope. This rule is far-reaching. It applies to all workplaces. It applies except where employees work from home or are working remotely from another location, or otherwise if they don't have any contact with others in the workplace. And there's also an important exception, which typically comes up in the healthcare context, where that workplace and the particular employees at issue are subject to the aerosol transmittable diseases standard, and that's in section 5199. And if you're subject to that rule, you'll know that, but you can't be, as an individual employee, subject to both the ATD standard as well as the ETS standard, and that's an important point to make. It's also significant that the ETS makes clear, and we quoted the language here, that nothing in the ETS is intended to limit more protective or stringent state or local health department mandates or guidance. And what that means essentially is that you can have more stringent requirements from the local Department of Public Health via healthcare orders or directives. And so that's been a major misconception that we've encountered with clients, is that it would appear that the ETS was designed to ensure complete consistency, but that has not been the case. There is a carve-out, particularly directed to the Department of Public Health. So you'll need to continue to follow those local Department of Public Health directives. And then moving on, now we'll delve into some of the key definitions. And to understand the ETS, you really need to understand the definitions and the terms that are used. They're really terms of art. A COVID-19 case is one term that's used quite frequently in the ETS, and that essentially, in most cases, involves someone who tests positive for COVID-19, but it can also be a person who's ordered to isolate by a state or local health authority. It can also be someone who has died from COVID-19 based on a determination by the Department of Public Health or state statistics. It's also really significant that a COVID-19 case can be any person. It does not have to be an employee. It can be an employee, it can be a non-employee, such as a customer or vendor that comes into the workplace. Now, another important term is COVID-19 exposure, and that's essentially a close contact. That term has been drafted in a way to be consistent with the CDC definition of close contact. So what you're considering is whether someone, for this definition, was within 6 feet of the COVID-19 case, which is typically the positive individual, and that contact has to be for 15 minutes in a total of a cumulative time over a 24-hour period, and that this exposure needs to be within the infected individual's high-risk exposure period, essentially when that individual would be presumed contagious. So let's move to the next slide. So we talk about specifically the high-risk exposure period, and that's an important term that's used throughout the rule. That term is divided into 2 categories. It's where you have a COVID-19 case, where that person develops COVID-19 symptoms. In that case, well, that's the first definition. And the second is where you have a positive where they don't exhibit symptoms. But where they do exhibit symptoms, you have to look at the time frame that's 2 days before the onset of symptoms as the start of the high-risk exposure period. And then you continue for 10 days after that first appearance of symptoms. And then you want to also look at 24 hours or ensure that there's a 24-hour period in which the COVID-19 case has not had a fever without the use of any fever-reducing medication, and in which the symptoms have improved. But for those positive cases where there's no symptoms, you just simply look at 2 days before they had the COVID test, and then 10 days after the COVID test, and that total period would be considered the high-risk exposure period. Another frequent and very consequential definition is exposed workplace. That comes up only in the outbreak context and the related testing when there's an outbreak. And for that, you are looking at the workplace, and you're looking at the work location or a common area that's used or accessed by a COVID-19 case. And that's really important to keep in mind. It's not the entire workplace. And I know when they were first proposing this rule and when it was enacted, it really appeared that you were looking at the entire work site as the exposed workplace. And that was creating major heartburn for employers and how they could possibly comply with this. But with clarification from DOSH and based on this definition, it's clear that you're looking at the areas accessed or used by the COVID-19 cases that are being considered for outbreak purposes. And you're also looking during the high-risk exposure period, which we've defined above. And then moving to the next slide. Okay, well, now I'm going to turn it over to my colleague, Fred Walter, to discuss the nuts and bolts of the ETS.
Good afternoon, and thanks for joining us. I will be handling most of the nitty-gritty of 3205 And in order to leave as much time for questions as possible, we're going to try to get through this fairly quickly. But I am going to hit on some things that I know that you need to know about. The first thing you need to know about the COVID-19 prevention program is that it is pretty closely modeled on the illness and injury prevention program in 3203. It follows the requirements of the IAPP. And so if you have experience putting together an IAPP, you should have little trouble putting together a written program for COVID-19. As with the IAPP, the COVID-19 prevention program has to be effective. And that means that the written program, if you want to think in terms of from an old John Wayne movie, in the written program, you're talking the talk. And if you have to make sure that it's effective by walking the walk and make sure that you cover what it is you're talking about in the program. It covers communications, covers investigating incidents and responding to those incidents. It talks about inspections and evaluating the workplace for sources of infection rather. And what you're doing to correct those hazards, and of course, training. Next slide, please. So sub 3 of 3203C talks about responding to COVID-19 cases. The very first requirement of this part of the regulation is that you give notice within a business day, within 24 hours, without revealing anything about the person who was COVID-19 positive. You have to identify employees who had close contact exposure. You also have to give notice to their union, if there is a union, of the exposure. You also have to give notice to any contractors that you have working and other employers present. Question was recently asked by one of our clients as to whether this includes housekeeping people who aren't necessarily subcontractors. But the answer would be if they're in the exposed zone for exposure to a COVID-19 positive case, the answer is yes. You have to, and this is the first time they talk about testing as well. We'll talk about that in more detail later, but even if you have simply a single COVID-19 case in your workplace, you have to offer free COVID-19 testing to all of those who are potentially exposed. And that gets back to the exposed work site and the exposed cohort of employees who may have been exposed to COVID-19. You have to pay for it if you're the employer, and you have to provide for that testing on the employee's paid time, not after hours, and not using other vacation or other benefits to cover the time they take to be tested. You have to make provisions for excluding COVID-19 cases and exposed employees from the work site. That has to be part of your plan. And we'll talk about that more in detail when we get down further into the weeds of the regulation. And the regulation says that you have to immediately investigate to determine the source of the infection and whether it's in fact workplace based or did it come from the outside. That's something to know. Next slide, please. Finally, well, not finally, but as important as anything else is maintaining employee confidentiality. You can tell exposed or potentially exposed workers that they may have been exposed to a COVID-19 case, but you can't tell them who it is. You have to keep records of the exposure, but you can't let that information be available to anybody else except for the local health departments you're dealing with, California Department of Public Health, Cal OSHA, NIOSH, or other agencies who by law may be allowed to see that information. So you have to keep that close to the vest unless the employee has given express written consent that they don't mind it being disclosed. Next slide, please. As we all know, the magic is in 6 feet. 6 feet of separation from workers. If that is, and the regulation says that 6 feet of separation is to be maintained unless it is not possible to maintain it. And there's some issues to whether possible is the best word to use, but that's what the word they're using right now. If you can't maintain 6 feet, you have to do your best to get employees as far apart as possible. And if that is not possible, we'll talk about what you do in the next slide. But right now, this section also provides that you, the employer, are responsible for providing face coverings. And it also says that you have to ensure that they are worn by employees. How you ensure that is your business. I will tell you, though, that under the IIPP, perhaps against type, the division is happy to see if there are provisions in the employer's plan for, blanking on the word. Anyway, if you have a stick to go along with a carrot, you can use that to ensure that employees are wearing their face coverings. Next slide, please. And finally, and this was a question asked early on by one of the attendees, what do you do if you can't maintain 6 feet of distance? The regulation says that you have to install partitions that reduce aerosol transmission. And the partitions are only needed under this regulation if it's not possible to maintain 6 feet of distancing. And in the answer to the other part of the participant's question, there is no guidance in the regulation or in the FAQs as to what the dimensions of the partition should be. But we do know from CDC guidance that they believe that aerosol transmission of COVID-19 can stretch to 24 feet. And I would think that a partition that is 6 feet high is going, for someone who's seated at a desk, is going to be or should be acceptable, but we don't know. The other part of this section that's interesting is the reliance upon natural ventilation, using outside air to the extent feasible to maintain airflow and keep the air fresh. You'll see that the EPA's air quality index of 100 is the threshold here. And that is interesting because it's a marked difference from the threshold in the wildfire smoke regulation. You also need to be sure that you can provide sufficient airflow, even if it means you're letting in excessively hot or cold air to the work site. And obviously, you need to be providing cleaning and disinfecting procedures. This should be part of your written plan as well. And it should be something that's done on a routine basis. The other part that's interesting here is that you have to proactively inform employees and their unions of what your cleaning and disinfecting protocols are. Can I have the next slide? There you go. And this is a word that, or a phrase that became common knowledge. It was known in the safety industry safety and health industry for decades, but now everyone in the nation understands what PPE stands for. You need to take steps to determine whether PPE is required for your employees, and if so, what types. And if the distancing, the 6-foot distancing that we talked about earlier is not feasible, do you provide N95 respirators or, N95 masks or something more substantial? If there is exposure to the eyes, then you're going to have to provide goggles. Next slide, please. So here we're talking about record keeping. Separate and apart from the 300 log, you need to maintain a record of those who are COVID-19 positive, regardless whether the source was on the job or not. You'll see here that you need to have in that record the employee's name, contact information, their occupation, where they worked, last day of work, and the date of a positive test. That all has to remain confidential. But if it's asked for by employees and their unions, it must be made available to them, redacted though, to mask off the identity of the employee. Next slide, please. Actually, let's go back to the one before. And I want to say something else about that. These records can be kept until they are asked for. Well, they have to be asked for by the division or NIOSH or the local health care departments. You're going to want to keep those in a safe place. I can't emphasize that too much because this information is as confidential as it gets. Next slide, we'll go on. C10 may be the most confusing and meaty part of the regulation. It has to do with exclusion of COVID-19 cases and exposed employees. The COVID-19 cases will be able to return to work as we discuss in the next slide. But you should know that exposed employees, those who are not positive but have been exposed as we defined earlier, need only be away from the work site for 10 days after the last known exposure. So that time is starts to count, starts to click down as soon as you know. Let's go back, please, to C10. Thank you. Yeah. As far as exposed workers goes, it's a 10-day exclusion period. While somebody is away from work, you need to be paying them their earnings. They need to maintain seniority, all of the rights and benefits. But this only applies in the event that the employee who is being excluded from the work site is able and available for work. If there are other reasons why they would not be able to work, you do not need to pay their earnings. You do not need to provide, you can make them use sick leave benefits. And you can't mix and match between the private benefits of earnings and public benefits such as workers' compensation benefits, unemployed insurance benefits or the like. It's one or the other. Next slide, please. So here we talk about return to work criteria for COVID-19 cases themselves. We first talk about people who tested positive and then developed symptoms. They need to meet these criteria, at least 24 hours since a fever of 104, and that has to be as measured without the benefit of ibuprofen or some other medication. They have to show improvement in their COVID-19 symptoms, and we don't have a definition yet or guidance on what consists of improvement. They're leaving that to us to determine. And then finally, at least 10 days since the COVID-19 symptoms first onset. So you have to meet all three of those if you had to let a COVID-19 positive case with symptomatology back into the workplace. Now, if you have a COVID-19 positive case, one who tested positive for the illness without symptoms, they have to spend, again, at least 10 days outside work until the date of the positive test collection has passed. And finally, and this seems to be counterintuitive, you do not require that somebody coming back from isolation test negative under a COVID-19 test. And this is because the CDC has determined that COVID-19 positive cases will continue to test positive for as much as 3 months, but not be communicable after the first 10 to 14 days. That's it for that. We need to go next to what you do 3205.1 with a multiple COVID-19 infections or an outbreak. Let's go to the next slide. This case, this determination is made either by a local health department coming to you and saying you are the location of an outbreak, which seems to me a little unlikely. I think it's more likely that you're going to know that you have had, and this is the formula, 3 or more COVID-19 cases in an exposed workplace within a 14-day period. And you have to follow the rules in this section until you have found no new COVID-19 cases in the exposed workplace over a 14-day period. So you exclude workers, for example, as being COVID-19 positive. They spend their time in isolation. They return to the work site. If you have reason to test again, not because they came back to work, but because something else happened, they would be, it's a question whether they are considered a new COVID-19 case if they test positive after this return to work period, after their return to work period in that 3-month period of time or not. However, for the most part, we're looking for no new COVID-19 cases in the exposed workplace over a 2-week period. Next slide. This, as before, and you're getting the drift, the employer must provide COVID-19 testing to all in the exposed workplace. And again, as Andrew said earlier, this doesn't apply to the entire workplace. It doesn't not the entire shop or factory, just where the COVID positive exposure existed. Testing must be free. And then because you've had an outbreak, you have to test again in a week's time. And if you continue testing weekly again until you have no new COVID-19 cases within a 14-day period. Next slide. So COVID-19 cases and exposed employees would be excluded from the workplace under Outbreak, same as an individual case and individual exposure would be under C10 and C11, as we discussed earlier. You're obligated to do what you are obligated to do under your COVID prevention plan. Immediately investigate and look for possible factors that contributed to the outbreak, and then take an immediate, and of course, correct them, and then take an immediate review of your policies and procedures to see if any of them can be beefed up to prevent further outbreak going forward. Next slide. And finally, although this probably should have been the lead off, you have a day to report to the local health department about a COVID-19 outbreak in your workplace. And the information you need to provide is the total number of COVID-19 cases, and for each, the same information that you're putting on the record of the COVID-19 case: name, contact information. However, here you have to add in the NAICS code of the workplace. That also is, that's all confidential information, but it has to be provided to the local health department for those and any subsequent COVID-19 cases that arise in the workplace. That's it for 3205.1. And now Megan Shaked will continue to talk about what you do when you have a really serious outbreak.
Thanks, Fred. Good afternoon, everyone. So section 3205.2 discusses major outbreaks, and you'll see a few of the same requirements exist for major outbreaks as do for the outbreak section that Fred just spoke about, with some additional requirements. So first and foremost, this section for major outbreaks applies when there are 20 or more COVID-19 cases in an exposed workplace within a 30-day period. And again, you have to comply with the requirements for a major outbreak in the same way. And you do that again until there's no new COVID-19 cases detected in the workplace for a 14-day period. So similar requirement to notify the local health department that there's been a major outbreak. Similar same exclusion requirement to exclude all COVID-19 cases and employees with COVID-19 exposure under the 3205 requirements. And then the testing requirement does differ from the regular outbreak provision in that COVID-19 testing needs to be provided twice a week. And COVID-19 testing in outbreak and major outbreak contexts is to the workers who were in the exposed workplace during the relevant period of time. So a bumped up testing requirement for major outbreaks, and the testing requirement is for those employees who were in the exposed workplace for major outbreaks during that 30-day period and who remain at the workplace. You have the similar requirements to investigate the sources of exposure in investigation and hazard correction. But the major outbreak has an increased or an additional requirement regarding ventilation, where you're using filters, certain high efficiency filters, or higher if possible, or the best available based on the system that you have. There's an additional requirement to kind of evaluate if additional air filtration systems may be required under your circumstances, and to consider whether use of a respiratory protection program might make sense, or whether changes might be necessary if you have an existing respiratory protection program. There's also a requirement to evaluate whether halting some or all operations until the hazard has been corrected might be appropriate under a given outbreak scenario as well. The last two sections of the emergency temporary standard apply for employer provided housing and employer provided transportation, which is a pretty specific kind of area. So if those apply to your workplace, you'll want to pay particular attention to the detailed requirements in 3205.3 and 3205.4. Just kind of go over a very high level understanding just to kind of flag this as an issue, which is that for employers with employer provided housing, there are specific requirements for prioritizing housing assignments in a certain order. And there's also specific requirements for physical distancing, face coverings, cleaning and disinfecting, as well as screening and isolation. So again, those are details to look at if those apply. And then employer provided transportation, it's a similar concept in that there's specific requirements for prioritizing transportation assignment. And then it also covers physical distancing and face coverings, screening and cleaning and disinfection, as well as ventilation and hand hygiene. So we're going to take just a quick pause to discuss two pieces of California legislation that were passed at the end of 2020 because they're intertwined quite a bit with the Cal OSHA Emergency Temporary Standard. And it's good to be aware of these and how they kind of work along with the ETS. They've certainly been raising a lot of questions and a bit of confusion. So the first is Assembly Bill 685, and this went into effect January 1 of this year. And it has two parts. So the first part is a notice requirement, and it requires notice to employees who were on the premises at the same work site within the infectious period as a qualifying individual. And the qualifying individual we can think of as a COVID-19 case. We can think of work site as similar to the definition under the ETS of the exposed workplace. And in fact, the definition of exposed workplace under the ETS now includes the definition of work site as it's defined under AB 685. And then the term infectious period as used under 685 is the same as the high risk exposure period under the ETS. Both basically rely on the current California Department of Public Health definition of, you know, the understood infectious period of a COVID-19 case. The written notice has to be given within one business day. If you have a unionized workforce, notice has to be provided to the union. And there's specific requirements for the written notice depending on who's receiving the notice. So for example, employees have to receive, the notice that they're of potential exposure to COVID-19, and as well as details about COVID-19 benefits such as workers' comp or paid sick leave, as well as the safety and disinfection plan. That same information has to go to a union rep in addition to some information that might that would appear on the OSHA 300 injury and illness log. And then if a notice is going to subcontractors, the disinfection and safety plans needs to be shared as well. 685, the second part is an outbreak notification. And this requires reporting within 48 hours of qualifying as a COVID-19 outbreak, which is 3 or more COVID-19 cases among workers at the same work site within the 14-day period. So that's a similar definition as under the ETS. And then specific information has to be included in the report. So it's good to make sure if you're making a report that you're complying both with the ETS and the 685 requirements. And then the second piece of legislation is Senate Bill 1159. And this one went into effect, actually, as soon as it was signed. It was emergency legislation, so it went into effect in September 2020. And it, again, kind of has two parts. The first is it creates a disputable presumption that a COVID-19 related illness is compensable for workers' compensation purposes. And that's generally where an employee tests positive for COVID-19 during an outbreak at the workplace, within 14 days of them being present at the workplace. And it only counts for employees whose last day of the whose last day in the workplace was on or after July 6, 2020. But the important thing to note is that under Senate Bill 1159, the definition of outbreak is very different than the definition under the ETS or 685. So for purposes of 1159, an outbreak exists if you're looking within a 14 calendar day period of time. For employers with between 1 and 100 employees, you need to have 4 employees test positive for it to be considered an outbreak. If you have more than 100 employees, you have to have 4% of the employees test positive. And there's other situations where the health department or Cal OSHA could also require you to comply with this as well. And then within 3 business days, an employer, upon knowing or reasonably, should have known that you've hit that outbreak level, then you have to report, scratch that. Within 3 business days of an employer learning about an employee testing positive for COVID-19, they have a reporting obligation to their workers' compensation claims administrator. So this is an additional reporting requirement that you'll want to track. For making a report, it has to be made a certain way, and again, it has to contain certain information. And with that, we're moving back to Andrew.
Thank you, Megan. So is this all perfectly clear? Do we know what this all means about all the notice requirements here? Of course not. There's so many different requirements, as Megan just outlined. We have AB 685 with one set of notice requirements. Then you have SB 1159, and then we have the ETS notice requirements. So there's been a number of questions already about the interplay of AB 685 and the ETS notice requirements. And I think what's really important to note is that the ETS is focused on the COVID-19 exposures, meaning the close contacts. So you're required to give notice to employees that are close contacts with the COVID-19 case, essentially the positive case. Whereas AB 685 is broader. You're focused on notice to employees that are within the same work site as the COVID-19 case, essentially the positive individual within the infectious period. And so what that means is you have a much broader disclosure under AB 685. And there's a number of different ways to handle that. You can give a broader notice to a broader set of individuals under AB 685 just for the ease of notice. But the notice is only required for those that are in that work site, which is a term that's similar to exposed workplace, meaning you're focused on the area where that positive individual has had access or areas that that individual has used. But when you get into an outbreak scenario, that's where the scope is quite important because of all the additional obligations that have been explained, particularly around testing. And so there you're focused on the exposed workplace, which is similar to worksite under AB 685. And there it's important to very thoughtfully narrow the scope of the exposed workplace to the one that actually is used and accessed for the purpose of then complying with the outbreak provisions. But I did want to discuss the frequently asked questions by DOSH. And it's really important to note, as I already mentioned, that this is not the law. So if you follow the FAQs to a T, doesn't mean that you're in the clear. So for that reason, we've been advocating with Cal OSHA to change the rule to the ETS to clarify issues and address many of the concerns that are raised in the frequently asked questions, so that we can be sure that if we need to litigate these issues, that the Cal OSH board would actually have a rule that's clearer and more limited in scope to rely upon. But turning to some of the FAQs, let's go to the next slide. We, just as background, you can go to, excuse me, you can go to Cal OSHA's site, DOSH, and there you can find the FAQs. There was an initial set of FAQs that issued, and they have recently updated them. There are now 69 questions. There's quite a bit of material there and some helpful clarification. And there is an indication that there will be further FAQs issued in the future. Now let's go to the next slide and start kind of diving into some of the most interesting FAQs. So next slide. All right, so exposed workplace. I think we'd be all lying if we said that this term was crystal clear, because there's nothing really clear about it. The guidance has helped us, though. At first blush, there was a bit of confusion because exposed workplace incorporates the definition of worksite under AB 685, but then it also has some additional verbiage that prefaces that. But I think in a nutshell, you really want to focus on, the work location, the working area, or the common area used or accessed by a COVID-19 case during the high-risk period. And that's been clarified by DOSH in FAQs. And that for a outbreak scenario, you are focused on 3 COVID-19 cases that share the same exposed workplace. So you're not looking at all of the areas where the 3 cases go individually, but you're looking at the areas where they overlap, where the 3 COVID-19 cases are together for the purpose of determining whether there's an outbreak. And then it's another important clarification is that Cal OSHA does not expect you to consider as the exposed workplace areas where individuals are masked and momentarily passing through without interacting or congregating. So if you have a hallway and you have an employee passing through just briefly and they're wearing a mask and they're not stopping to talk with others, then that area would not be considered for the purpose of determining the exposed workplace. Now let's move to the next slide. Okay, so let's just go through these briefly. This further reinforces some of which I have explained, is that the exposed workplace does not mean it's the entire building. So the question is, does the exposed workplace mean the entire building? The answer is no. It includes the areas of the building where the COVID-19 cases were present during the high-risk exposure period. And then, is the outbreak testing triggered by 3 or more cases in an entire building? No, the framework is not necessarily the building. Testing requirements are triggered by 3 or more cases in a 14-day period present in the same exposed workplace during the high-risk exposure period. So you're going through that analysis, determining what areas they accessed or used to identify the exposed workplace. And this is by me no easy feat. And so this may be an area where you need to consult with counsel to really assess what the exposed workplace is for outbreak purposes. And this is really worth the additional thought, because if it is an outbreak, you are required to conduct that weekly or twice a week testing, depending on whether it's an outbreak or major outbreak. And then if you don't identify as an outbreak, then you can have potential liability with Cal OSHA. The next question is the 3+ cases for outbreak requirement limited to employees, or do cases involving anyone who has been in the workplace count? And a really important clarification here is it's any confirmed COVID-19 case. So it can be a cluster of individuals that involve employees and non-employees during this 14-day period for an outbreak, or 30-day period for a major outbreak. So let's move to the next slide. All right, so the next question is, how can employers measure the 14 or 30-day period in which to look for positive cases to determine if there has been an outbreak or a major outbreak? And this is an area where we have a bit of disagreement with Cal OSHA. The measure, and it does seem a bit artificial, is they're looking at the date of, it says here, employers should look to test dates of the cases. So you're looking at when these individuals had their COVID tests, which ultimately resulted in positives. And then you're looking at whether those test dates, when you compare them and you compare the exposed workplace, show a pattern within a 14-day period. Now, this seems problematic because you can have a situation where someone is positive for a period of time. Maybe they have a delayed test, and it may be more relevant to look at the onset of symptoms where there are symptoms. So if the person is not asymptomatic and they have symptoms, it seems that it would be a better gauge to look at when they first develop symptoms, but that's not the test. The test and the consideration is specific to the test dates. And now let's move to the next slide. Okay, and this was a question that was already asked by a couple of you. What do employers do if employees refuse to take the test required by various provisions of the emergency regulations? And the answer is, an employer that offers a test at no cost does not violate the rule if an employee refuses to take it, and that the employer is not required to obtain a signed declination from employees who refuse the test. So you're not required to get a signed declination, but our recommendation is that you do that, and so that you can show that you did offer the test. And there's no dispute about that after the fact. We have a bit of a note here, though it's not addressed in the FAQs, our firm's opinion about removal and paid continuation for employees who declined testing is as follows: that if employee had a close contact exposure, and that's an individual that declines a test, you would still nonetheless quarantine that individual during the required period, and that individual would receive exclusion pay continuation potentially. If the employee is not a close contact, and there's no need to quarantine that individual. So if you have an outbreak situation where you are testing everyone within the exposed workplace, and the individual that declines the testing is not a close contact, then you can simply exclude that employee. There's no obligation for paid continuation, unlike the situation of a close contact. So let's move to the next slide. And this is a question that comes up often, and there's a good reason why it comes up, because the ETS suggests that the testing has to be on site. DOSH has clarified that's not the case. Does the employer have to provide testing at the work location? No. The employer may provide testing to employees at a testing site separate from their work location. The next question, can employers send employees to a free testing site? And is this considered to be at no cost to employees under the ETS? Yes, an employer can send an employee off-site as long as employees incur no cost for testing. and you have to pay wages associated with the employee traveling to the testing site and for their time being tested and returning to work, as well as any travel costs. And so that could be mileage or public transportation costs. We do have many businesses we work with that have decided in outbreak situations to do the testing on site because then they don't have the associated costs with travel for employees to go off site. And also there's conveniences for employees to have the testing on site, but that might not always be feasible. And then the next question, what does during employees' working hours mean in relation to providing COVID-19 testing? And critically, DOSH has clarified that while the employee must be compensated for time testing, the employer is not obligated to provide tests during employees' normal working hours. Okay, and I think there might be some more FAQs. Why don't we continue it? So we have 2 more slides on this, and then we'll open it up to some questions. There's some return to work FAQs. And one significant one is, what are the return to work criteria for an employee exposed to a COVID-19 case in the workplace? And so there is an exclusion requirement. And here under the ETS, there's a blanket requirement that the exposed employee, meaning the employee that's a close contact, be excluded from the workplace for 14 days for quarantine. But there is guidance, or essentially there's an executive order, it's not guidance, that carves out an exception where you have an employee that is asymptomatic and meets other requirements in connection with their return to work. In that situation, they may return in 10 days after the last known exposure. There's also critical staffing shortage exceptions, but that's specific to healthcare, emergency services, social services. I think there was a question that was raised about critical infrastructure exceptions. There is nothing expressly recognized under the ETS, but there is a mechanism to seek a waiver through to DOSH, and there's some guidance on that in the FAQs. And that's based on undue hardship. It seems to be a hefty burden, and it's unclear exactly how much time it would take for DOSH to respond to that waiver request. So it may, in the end, not be terribly viable. Only time will tell. Now, regarding vaccines, we're all hopeful that we will be vaccinated soon. The ETS make clear that for now, all the prevention measures in place will apply even if someone is vaccinated, but there may be a revision to this guidance in future FAQs. I think, is there one more slide? Okay. Oh, and this will be brief. There is a recognition in the FAQs that, there has been talk by DOSH that they would be lenient in enforcement, at least early on, since this is obviously quite an onerous standard, and it's impossible, maybe not impossible, but unlikely that all employers within days of the enactment of the ETS will be fully up to speed and compliant. And so they've provided some latitude in that DOSH takes a position that they will not issue monetary penalties if an employer is otherwise compliant with California law before the ETS took effect. And that they will not seek those penalties through February 1st, which is coming up, but that they could still cite. And we have seen citations already, but over IIPP violations and reporting standards related to COVID-19. And I expect that there will be a wave of citations issuing under the ETS in the short run. So let's move to the, actually this is the last slide, and then we'll open up for questions, but we want to have our top 10 list here. And these are really the important takeaways. That the reminder is that this is a work in progress. This is evolving. The ETS was rushed through, and it was, as an emergency rule, not conceivable that in the time frame in which it was adopted that it would be crystal clear and address all reasonable concerns. But there were more concerns than we anticipated. And the advisory committee in which we'll be participating will be proposing changes, and we're hopeful that changes will be incorporated into amended rule over time. We discussed the penalties and that there will be citations, but no penalties through February 1st under the emergency temporary standard. The industry specific guidance, this is number 3, is helpful. It gives you some understanding of the logic by DOSH for this rule and helps you analyze these issues. But at the end of the day, if you are on appeal with the agency, you can't cite to industry specific guidance as the law. But in any case, number 4, review the FAQs with this cautionary note in mind. Continue to assess work relatedness. So it's important, as Fred was talking about, you have to conduct an investigation when you have a positive case. And it's important to conduct a work relatedness assessment. And that has a couple really important goals. One is you'll want to determine whether the COVID case is work related for the purpose of OSHA record keeping, whether you put that case on your OSHA log. You also want to consider that case for the purpose of determining whether you need to report that illness to Cal OSHA where there's inpatient hospitalization or a fatality. It's also critical to, to other, it's also one really important point is pay continuation. There is no requirement for paid continuation for excluded employees where you can show that the illness is not work-related. So that's another reason why you'll want to have this analysis. Consider cohorts, other ways to reduce the exposed workplace. So employees, for example, who work in a warehouse setting where you're concerned that you might have one big, large exposed workplace, you might find ways to isolate the employees so that they're not all interacting, and that can be done through them not sharing break rooms. That can be done through shifts or the areas in which they access. That's a really helpful way to reduce or prevent the transmission of COVID-19, as well as to narrow the scope of the exposed workplace for outbreak reasons. You want to continue to evaluate and reevaluate the workplace as you have positive cases. I mean, given the pandemic, there are going to be positive cases in workplaces, but there may be information obtained in your investigation where you identify ways where you can improve your COVID-19 prevention measures, whether that be engineering controls, administrative controls, or whatnot. And then number 8, consider obligation to pay excluded employees along with other leave obligations. When you have an employee that's excluded, you need to go through the analysis to determine whether that employee is able and available to work, and whether the illness is work-related for the purpose of determining whether you have a continuing pay obligation. And there may be leaves of absence available even on unpaid on an unpaid basis. And then you'll need to understand the overlapping notice and reporting requirements. As we talked about, the ETS and AB 685 are not consistent. So you might have multiple notices going out where there might be some overlap between the employees. There are ways where you can combine the notices. It just may be a little bit more work. And I think lastly, you all must have a COVID-19 plan in writing. And that is, we've worked with our clients on those. And it's important to have a plan that identifies the core elements under the ETS, and that you not only have that plan, that you undertake efforts to implement it. And that's through training, education, and various different measures in the workplace. So with that, we are done with the presentation. We'll open it up to some questions for the remaining minutes that we have. Fred, was there anything that you saw in the chat line that you wanted to respond to?
Hang on a second. Okay, there. Technically challenged. The questions I got and I've been answering a few of them as you were speaking. One had to do, the earlier one had to do with whether you need to consider barriers or partitions if you're able to keep workers more than 6 feet apart. I think I discussed that pretty well in my first presentation. Just received an inquiry asking for, as you got done with number 9, asking for some understanding of the overlapping notice and reporting requirements between the ETS and AB 685. The question I answered was specific to notice, and I made the point that notice requirements under AB 685 are far broader than under the ETS. Under the ETS, you're responsible to give notice to exposed workers and to the union if applicable, but not necessarily anyone else. Under AB 685, you're responsible to give notice, and not just notice, but written notice to all employees in the workplace and to their union as well. That in a nutshell is the difference between the two. And as far as reporting requirements go, there's the notice, I'll leave you to discuss AB 685. The reporting requirements in the ETS are pretty straightforward. If you have an outbreak, if you have a major outbreak, you have reporting responsibilities. And you have responsibilities also just under the plain old 3205 if you have somebody who's COVID positive. Andrew?
Yeah, and I think I would just reiterate that the notice requirements, the verbiage is so different under AB 685 and the ETS that you just really need to consider the individual language. And under the ETS, the notice is to the employees and their union. And then you also have notice to the employers of subcontracted employees, which is just a very ambiguous term. And we've had some internal debate about what that means. So you're probably in your own workplaces scratching your heads and trying to figure out what this all means and talking amongst yourself. We're doing the same thing, Fred smiling, because it's just, there's not absolute clarity to any of this. You know, some terms are less clear than others. And then there's also the requirements for notice to other employers and subcontractors under the ETS. And so there is, I think there was one question about what to do if you have under the ETS, if you have someone that might be a close contact who say is in housekeeping, but that person is employed by a business with which your company has a relationship. It would appear under the ETS that the notice would be to the employer, not to the individual.
Correct.
You agree, Fred? Okay.
Well, that's also true under, isn't that also true under AB 685?
That's correct. That's how
one of the last questions that I saw and I didn't have time to formulate an answer to, and I'll lean on you and Megan for this as well. What about situations where you have contract workers? Who's the employer who's responsible for conducting the testing and the notice? Is it the owner of the shop, or is it the labor company?
Oh, that's interesting. So, and are you referring, Fred, to this would be testing in a non-outbreak setting?
The question that was asked wasn't specific to whether it was under 3205 or 3205-1 or 2. Just, you know, if there's a responsibility for testing a worker, mm-hmm. and it happens to be one that we have contracted for, we don't actually stand as the employer for this worker. Who pays for the testing?
Mm-hmm. So you know, how I'm reading the ETS is that it's focused on the employer vis-a-vis their employees. So the obligation is to provide testing to your own employees. If it's a third party, an individual employed by someone else, then it would be the employer for that individual that would have the testing obligation. And so that's a bit unusual. And there, there may be situations where the employer offers the testing, even though not required, to the third party individual. But there's a really important note is you might have a situation where you're calling the person a consultant, but under the law, they're an employee, right? So if you look at the typical employer-employee test versus independent contractor, if that person is a consultant, but from, when you look at the nature of the relationship, the person's really your employee, then you would be obligated to provide testing and assume all of your other obligations under the ETS as an employer of that individual.
I wonder, I think you're probably right. I wonder if the division wouldn't fall back on the cases that address the relationship between general and special employers under dual employment. Mm-hmm. I also sense another paragraph being added to those contracts for contract workers to spell it out. That may be, I don't know. I think that may be the best way for to go to make it clear in terms of contractual obligation as to who is going to do the testing and who's not.
I think that's a really good point. I think that's something that should be clarified with businesses with which a employer contracts for services, and to ensure, and usually those agreements have some clarification about their respective responsibilities, and that could certainly be inserted into an agreement, or could merely be a communication to that entity. And these are uncharted kind of waters to a degree. It's a really unique new standard, and so we're still seeing how it plays out. And once there's citations, and these citations are litigated, we'll have a better sense of what positions the agency is taking. I think an important note is it really depends, as many of you have likely experienced, on the compliance officer that comes out to inspect you in any given situation, and whether that person's going to nitpick the workplace or is going to conclude that you've acted in good faith. And I've seen both so far with clients. This is pre the emergency temporary standard, but I've seen situations where the compliance officer just says, this is a really hard situation with COVID, and you're just doing the best you can. You're acting in good faith. We're not going to cite you. And then there's other compliance officers that have been nitpicking and finding areas where they have perceived violations.
And we have seen situations where the COSHO congratulates the employer on doing a really good job, and then goes and thinks there's no citation, goes back, talks to the district manager, and the next thing you know is the employer has a serious citation issued to them. I think we can take some solace in the fact that I think the rollout of enforcement of this regulation has to be in part because the division doesn't quite understand how they're going to handle it. I'm sure that they're looking at this regulation as we are and trying to figure out what parts of it mean and how they fit together with their responsibilities under AB 685. So if that's any solace to the people out there attending this webinar, I hope it makes you feel better.
Right, and there was a reference in one question to I think it's a good term, murky health orders and regulations. So I guess they're not regulation. Well, the regulations can be murky, but the health orders and directives certainly are. And it's really important, as I indicated earlier, that you be aware of the local health orders and directives on COVID in your area, and that you comply with them. So even though you don't need to report in a certain situation a COVID case to Cal OSHA, you may have to report that to the local Department of Public Health, or you could simply have an inquiry from the local Department of Health asking for all sorts of information. They have fairly broad authority on the type of information they can ask. That being said, we've found many situations where the health department teams up with the employer and they want to see you succeed. And so there may be a way that you can work with them and show that you're taking the situation seriously, you have the measures in place, and hopefully not have too much follow-up after that. So actually, if we go to the next slide, I'd like to share our task force information on COVID-19 that our firm has set up. We also have on the next slide information about our blogs. So, you know, we have a deep bench of OSHA specialists in our firm, and we have a number of different webinars throughout the year and a blog on all things OSHA and as well as employment. And we have a number of different articles on these issues. And so for more information, you can certainly go to our website, and you can sign up for our blog or for our distribution of the webinars. And then if you have you know, any need for support, you can certainly reach out to any of us individually. There's a lot of content here. We'd like to really discuss this for hours if we could. But I think we've gone way over our allotted time, and we very much appreciate you attending. And again, you know, further materials you can find on our website or through us. Thank you.